Hi, I'm Erin, and I'm an estate and legacy planning attorney at Nobles Law. Today I want to talk to parents about the 7 must-dos when naming a guardian for your minor child. Okay, number 1, if you name a couple to act as a guardian, make sure you think about what you would want happening if the couple separates before the guardianship comes into place. Make sure that this is expressed as unambiguously as possible so that there's never any confusion about who should take custody of your children. Number 2, name more than one potential guardian. I like to follow the rule of 3, where you have at least 3 separate guardians identified, just in the case that your first choice is not available. Number 3, avoid taking finances into too much consideration when you think about who would be the best guardian for your child. There are a lot of ways that we can structure your estate plan so that money is not something that you should even think about when you're choosing who's the best person to be supportive and nurturing guardian in your absence. Number 4, consider creating a revocable living trust so that the guardians and anybody responsible for money that goes to your children do not have to go through a court process to get access to those resources. Number 5, if there's anyone that you can think of who might come forward to be a guardian for your child that you would not want to be in that role, consider specifically excluding them. This can be done discreetly so that it would never come to light that you did not want them in that role unless they challenged the person that you named as guardian. Number 6, make arrangements for short-term guardians. I think that this is critical because there are many situations where perhaps you haven't passed away, but you're still not able to care for your children. Make sure that you've named an emergency temporary guardian who could take immediate custody of your children within about an hour of you not being able to be there for them. And number 7, this is related to number 6. You want to name those emergency guardians and the more long-term guardians in a document that's separate from your will. And that's because your will only takes effect if you've passed away. But you could be injured, you could be missing, or you could be incapacitated and unable to care for them. Your will and the guardianship nomination that you made in your will doesn't have any legal effect. So make sure that you have made that appointment of your temporary and your long-term guardians in a separate document. At Nobles Law, we help our clients work through all of these different scenarios. It's difficult as a parent to think about a situation where you're not able to care for your children, but it's essential that you do this and put a plan in place today. If you have any questions or you're ready to get started, reach out to us at info@nobleslaw.org.